There is no constitutional issue here. The command of the Constitution is plain. There is no moral issue. It is wrong, deadly wrong, to deny any of your fellow Americans the right to vote in this country.
In order to understand what things were like when the Voting Rights Act was implemented in 1965, we do have to take a little bit of a journey back to the past. Okay, so we have to visit the hand of the past. And part of what we have to understand is why it was necessary to push back against these Jim Crow voting laws, okay? One of the things we know is that the purpose of elections is to turn preferences into government by electing people, okay? And in a democracy, one thing we expect is that we're going to have representation for everybody, including minority opinion, which means you have to have a way for that opinion to get expressed. Well, if you don't have the vote, it's really, really hard to have your opinion expressed and have it taken seriously by politicians, because votes are the currency they deal in, right? Votes keep them in power, and they respond to constituencies who can give them votes or give them the resources to help them get votes, right? So you either respond to voters or to the money that helps you get voters, okay? So if you go back and you look at the South, and you look at the South right after World War II, we have just seen the Supreme Court strike down a thing called the white primary, okay, down in Texas. It's the third time that the white primary has been stricken down in Texas in a 20-year period. And every time the federal courts would strike it down, Texas would go back and tinker with their law in order to make sure that the Democratic Party primary was a whites-only club. And every other southern state did this, okay? Democratic Party primaries were whites-only clubs. Republicans really didn't exist as an electoral option, and the goal was to put up a barrier to black voter participation. Now, those barriers have been going up ever since 1877, okay, ever since the end of Reconstruction. And there were a whole bunch of tools we had available that were used to completely disfranchise black voters. A white primary was one example. The Democratic Party primary is closed to anybody who isn't white because it's a whites-only club, it's a private association. You can vote in the general election, but it won't matter because the only candidate on the ballot is who was nominated out of the white primary. We had literacy tests, literacy and understanding tests, implemented by local voting registrars who were white, who wanted to keep blacks from voting. And they had tremendous discretion in how they implemented those voting tests. And it gives the registrar the ability to look at somebody and say, you did well enough, or no, you didn't. And one consequence of this is if you went someplace like Dallas County, Alabama, Selma, right? If you went down to Selma, you discovered the county was 62% black, but only about 1% of the registered voters were African American. So this was used to great effect to disfranchise black voters, especially in majority black counties. As Robert Toombs put it after the Civil War, these laws saw to it that the white man would rule and that blacks would be safely irrelevant, okay? So this is the mindset of the South, especially the Deep South. Keep that black vote irrelevant, see that whites will rule. And these laws and other laws related to them, but mainly the literacy test, the white primary, to a lesser extent the poll tax, are designed to keep the electorate small and keep it white. And what happens is, combined with intimidation and violence, economic intimidation and physical violence, blacks are kept away from the polls, okay? Now, there's a real scare that gets put into the white public in 1946, okay? And here's what happens is the state of Georgia has their white primary struck down in federal court. And they have a special election for Congress in a congressional district in Atlanta. And the black electorate really turns out in this special primary, okay? Because the white primary has been turned aside, black voters from what's called the historic Ward 3A of Atlanta show up to vote, and they're able to put a liberal female lawyer in Congress from Atlanta. She was not the choice of the conservative Democratic Party machine, okay, but she won. The power of the black vote had been demonstrated. And this leads to a hard pushback in Georgia politics and in other parts of the South to ensure that if you couldn't keep the white primary, you'd find other means to try and minimize the impact of the black vote. Throughout the 1950s and 1960s, this results in active pushback and often violence against people who sought to register blacks to vote. So if you look at the Freedom Riders, the early 1960s, who are going through the South in an effort, these are progressive blacks and whites from the North riding through the South in their buses to participate in efforts to mobilize and register black voters in Mississippi. Their buses were attacked and burned in Anniston, Alabama, for example, home of a U.S. military depot, attacked and burned. A bus full of people trying to register people to vote. The violence was getting out of hand, and it finally comes to a head in 1965 in Selma, Alabama, where we have a group of peaceful marchers being led in part by John Lewis, who later on is a black member of Congress from Atlanta, being attacked by state authority, state police and National Guard, at the Edmund Pettus Bridge in Selma, Alabama, and being denied the opportunity to register to vote. President of the United States, a Texan by the name of Lyndon Johnson, goes to his Attorney General and says, give me the toughest goddamnedest voting rights law you can write and get through Congress. And by August of that year, that legislation has been signed into law. And it gives to the national government extraordinary authority in an emergency situation to guarantee voting rights. Well, in 1965, the act is passed, and there are really, there are 4 provisions of the law that are worth knowing about, okay? One is what's called Section 2 of the Voting Rights Act, and this gives operational form to the 14th and 15th Amendment of the Constitution. It takes the goals of those amendments to ensure non-discrimination and equal protection under the law, especially with voting rights, and gives it shape in the form of legislation. And in particular, what it does is it allows an individual or the U.S. attorney to bring a lawsuit against a jurisdiction for discriminating against voters on the basis of race, okay? So if I am a voter in, Ferguson, Missouri, and I believe that the electoral system is designed in a discriminatory fashion, it's implemented in a discriminatory manner, it dilutes my equal opportunity to participate under the law, I can go to court, in federal court, and sue Ferguson over the conduct of their elections. It's a hypothetical. I'm talking in a hypothetical. And then the burden of proof is on me as the plaintiff, as with any civil action. I have to demonstrate by a preponderance of evidence and using the best available science that there's a discriminatory system here. Myself and people like me are discriminated against on the basis of our race and having equal opportunity to participate in electoral politics. Section 2 is the vehicle for that. And that provision of law is permanent, okay? When it was enacted in law, because the burden is placed on the plaintiff, because it applies to the entire country, because it gives part of the Constitution operational form, it's a permanent part of the U.S. Code. Congress would have to explicitly repeal it, or it would have to be explicitly overturned by the courts to go away. Challenges were brought against that part of the act, they failed. Now then there is what's called Section 4 of the act and Section 5 of the act. And Section 4 is what's called the coverage trigger. Part of the act was designed to address discrimination in parts of the country where there was an honest-to-God crisis, where we have a democratic crisis at work. Violence, intimidation, the state is actively denying people their constitutional rights. You were dealing with parts of the country that had bad intent, okay? They were actively, knowingly engaging in acts to deny democracy and to deny people their individual rights. So you had to preempt that activity. So what Section 4 of the Act did was it identified parts of the country where we deemed there to be a democratic crisis, okay? And it was based upon 2 criteria. The first criteria was, did you have a test or device in place to qualify people to vote? So we're using a literacy test, for example. And the second criteria was either voter registration or voter turnout in the 1964 election less than half of the eligible electorate. So you identify the size of the population of people who are eligible to vote, right? So these are basically citizens of age 21 or above, and the census has those data. If less than half of them turned out or less than half of them were registered and you had a test or device, what happens is your election laws are frozen in place, okay? Your election laws are frozen in place and they can't be changed unless the change is either approved by a 3-judge federal panel in Washington, D.C. in the D.C. Circuit Court or approved by the Attorney General of the United States. What's happened is Congress has given to the national government, to the Attorney General, the authority to suspend the right of states and localities to conduct elections. This is extraordinary. This is the single greatest exercise of federal power over a state since Reconstruction, when all civil government was effectively suspended by the Reconstruction governments. The American South existed under military rule for a dozen years under military districts after the Civil War. A lot of people don't know that. And that's part of why there was the intense desire to roll back black voter participation in the South from 1877 forward. So anyhow, you're going to suspend the ability of these states to change the law, right? And so what they do is in all of Virginia, South Carolina, Georgia, Alabama, Mississippi, and Louisiana, and in 40 counties in the eastern part of North Carolina, election laws are frozen in place. You can't move a voting precinct without the Attorney General approving it. You can't change congressional district or state legislative district boundaries without the Attorney General approving it. You can't change your voter registration practices, your ballot design, anything, unless the Attorney General approves it. And this authority exists under what's called Section 5 of the Voting Rights Act. It's called the pre-clearance provision. And what a state or a jurisdiction has to do if they change their law and they're covered by the Section 4 trigger, you have to come to federal court or come to the Attorney General, and you have to demonstrate that your change in the law doesn't hurt the status quo for minority voters, okay? So if you've got a 40% registration rate for black voters in your county and a 40% participation rate, and you're going to change the way you run your registration, you're going to change your registration form, you are going to change your office hours for your registrar, you are going to change the location of polling places, you have to affirmatively demonstrate to the satisfaction of the national government this will not make black voters worse off. It's called the non-retrogression standard. So Section 4 dictates where there's an emergency. Section 5 gives to Congress gives to the Attorney General on behalf of Congress the authority to review changes in election law. It's a lot, I know, it's a lot. It's a very detailed thing. What does it mean practically? Well, first of all, it's deemed emergency legislation. So initially this provision of the law is only in place for 5 years. And then Congress comes along after 5 years, holds hearings, extends the law for another 5 years. Then they hold hearings again and extend it for another 7 years because you have a lot of experiences of southern states still acting in bad faith. So every few years Congress is having to revisit this law. They're constantly in debate on it and they're getting tired. So in 1982 the law comes up for renewal again. And they do some things to correct the law to make it a little easier to sue under Section 2. But the other thing they do is they extend the time period of Section 5, that emergency provision. I'd talk about it. This part of the law had suspended laws in place for 5 years and then 5 years and then 7 years, right? They decided, well, we need about a quarter century of this. So they renew the law from 82 until 2007. And the reason they do it is to just get the damn issue off the table. They're tired of debating it. They're just going to lock it in and let it run. And they do something unusual, which is they change the evidentiary standard to have your election laws suspended in place, okay? If we loop back, the coverage formula under Section 4 of the Act said you're going to have to have had a test or device in place and had less than 50% registration or turnout in 1964. Well, in 1970, when they renewed the law, they updated it to say, we're going to use 1968 electoral data. Makes sense, most recent election, is there improvement? And then in 75, when they renewed the law, they went back and said, we'll use electoral data from 72. Again, the most recent election. When we get to 82, they don't update to use the electoral data from 1980. Instead, they lock in the data from 72. They say, okay, test or device and turnout participation based upon the election of 72. That's how we're going to determine if you have low turnout in 72, have a history of a test or device, your election laws are basically frozen in place, your ability to change them are suspended. Please come see us at the Attorney General's office if you want to change your law and bring your evidence that you're not discriminating. So they've locked in using old evidence that'll age out increasingly from year to year, which means that the experience of the present is not going to necessarily reflect what the hand of the past said. So we get to 2005, 2006, and the Republicans in Congress realize that they want to get this law renewed. And one of the reasons they want to get it renewed is its application and redistricting had really been beneficial to Republicans, especially in the South. That by jamming as many black voters into as few congressional districts and as few state legislative districts as possible that represented opportunities to elect, they diluted the ability of Democrats to compete elsewhere, especially in the South, but also in other parts of the country. So they've been using the Voting Rights Act as a wonderful political tool, in part based upon this pre-clearance provision under the Attorney General's office, to force the shaping of congressional districts that were good for African American and Hispanic voters, but also really, really good for white Republicans. So it's accomplishing its more noble purpose of assuring electoral representation for blacks and Latinos, right? But in the process, it's also been enabling government that's far more conservative than those voters. And that makes for a very interesting situation. So what Congress wants to do is they want to lock in the coverage formula for 25 more years. And they push forward a version of the law that keeps it exactly the same. Electoral data 1972, historic use of a test or device. And at the time, that actually seemed like it might work. Mississippi had the highest rate of voter participation among blacks of any state in the United States, followed by Alabama. And you were more likely to be a black person represented by a black lawmaker in Mississippi than if you lived in New York City, okay? So this law is working. Man, this thing is working, it's doing good. And, you know, the thought among those of us who thought it was time for change was, lessons have been learned. A corner has been turned. Things are better. At the same time, litigation is being prepared to be brought against this emergency provision should Congress not update it, okay? So here's what happens is Congress passes this law without change. They have a testimony trail that says there's a vulnerability here. And here's the vulnerability. There had been a case out of Texas dealing with religious relics called the City of Bernie case. And what it argued was that old evidence of behavior, say 40 years old, was not sufficient grounds for Congress to create a statute, okay? That evidence had to be timely and relevant to the problem. This is seized upon by litigants who want to challenge coverage under the Voting Rights Act, saying, you're asking Congress to make use of 35-year-old data, 40-year-old data, to decide who it is and isn't discriminating and who should and shouldn't have their constitutional guarantee to conduct their local elections without interference. That doesn't sound like it's kosher with other precedent, right? Lawsuit gets brought down in Texas by a little utility district in Austin called the North Austin Municipal Utility District Number 1, NMUDNO. What had happened is this little utility district, which conducted elections in one precinct, wanted to be freed from oversight by the Justice Department. They had asked to be what was called bailed out from coverage. Now, there had been a set of counties in Virginia that had done this previously. They presented evidence in federal court and to the Attorney General's office saying we don't need to be covered by Section 5 of the Act anymore, and they got bailed out. So they were free, the federals were taken off them, they could supervise their own elections. Texas, this little Texas utility district down in Travis County tries to do the same. They're denied by the Attorney General's office. They bring a lawsuit, they go to federal court, they appeal to the Supreme Court, and the Supreme Court says, you know what? You're right. You should have been allowed to bail out. You've met the standard. The Attorney General's office is not acting in good faith towards you. You need to be allowed to bail out. But in writing the opinion, the Chief Justice also articulated his belief that Congress had created a flawed law in not updating the coverage formula, and invited Congress to fix the law. Here's what happens. Shelby County, Alabama, suburban county outside of Birmingham, seeks to get out from under coverage under the Voting Rights Act, Section 5. They ask to be set free. They're denied by the federal courts. Okay, they're denied by the Attorney General. They appeal to the U.S. Supreme Court. 5-4 decision. Supreme Court says, you're right. Coverage formula is too old. It's 40 years old, based on 41-year-old data. Congress was cautioned this was a vulnerability. We invited them to fix it. The circumstances of Shelby County now are not the circumstances of Shelby County in 1964. Congress needs to fix this coverage provision. Since they failed to do so, we're striking it down. They didn't strike down Congress's authority to have an emergency coverage formula to address this kind of problem. They struck down Congress's authority to use bad and old evidence. So what happens is this wonderful, powerful tool designed to deal with the Ross Barnetts of the world, who say you can change law faster than Congress can strike them down, is taken away. And within hours, those of us who had assumed that maybe things were getting better 7, 8 years ago, either something changed again or the Confederates are coming out of the attic, okay? Because now all of a sudden, every voter ID law in the South is being pushed forward with implementation. There are states that are looking at doing things with redistricting to try and ensure that they're maximizing Republican advantage, because now the white vote in the South is predominantly Republican. All these steps are being taken to act on voter participation to make it more difficult. So if you were to look at, say, the Texas voter ID law, okay, this is a law that probably violates the 24th Amendment of the Constitution as a poll tax. It makes it needlessly difficult to register to vote based upon the variety of different forms of information you need to have available. It costs about $70 to get all that stuff together if you don't have it. That's the best estimate from expert testimony from litigation down there. In the state of Alabama, Alabama shuts down a whole bunch of motor tag agency offices, mainly in predominantly black counties, because that helps impede using motor voter as a vehicle to register people to vote. Had the Section 5 of the Voting Rights Act been in force in Alabama, the Attorney General's office would have stopped them. Okay? So what you see is you see small efforts to push back coming mainly out of Alabama and Texas, but also elsewhere. So now we're looking up and asking the question, are we backsliding? We need a new coverage formula, and we need a new voting rights law. Our belief as the authors of Rise and Fall of the Voting Rights Act is that these problems exist in the South, but not exclusively in the South. They also exist in Indian country. They exist in communities with large in-migrant and large Hispanic populations. They probably still exist in Alaska, okay? And what we need to do is take a very careful look at what the best available science says about where the problem is and give Congress a predictable trigger that they can implement into law. But what it needs to be is it needs to be a law that's dynamic and deals with modern voting problems. It deals with not getting rid of voter photo ID, but assuming that if you have voter photo ID, that it's free and it doesn't discriminate. Assuring that someone who wants to register to vote can do so without having to jump through a bunch of hoops that have been contrived to make it difficult for them, okay? And there's a real division in this country over how you approach voting. Oregon and California are now using what they call opt-out registration. You turn 18, congratulations, you're registered to vote. That's it. You don't want to be registered, you have to let the state know, I don't want to be a voter. Meanwhile, down in Texas, voting is treated like a privilege in that you have to qualify yourself, affirmatively go to register, and demonstrate you are who you say you are, okay? And that is an interesting challenge because voting in state constitutions uniformly is deemed to be a fundamental right. Okay? Fundamental rights cannot be impeded. Okay? They cannot be impaired by attacks. They're fundamental. They're part of who we are as individuals, part of your human sovereignty. In America, the one criterion that can definitively be put on registration is you need to be a citizen. States can make that choice. They can determine that you have to have reasonable residency, okay? But they can't say you can't vote because you're poor, or a woman, or black, or Hispanic, okay? As long as you're over 18 and a citizen, you're supposed to be part of the club, so long as you're a citizen of the state in which you seek to vote. And that's the real challenge we have right now, is trying to figure out how to get together a legislative majority, together with an executive, who can put together a good faith voting rights law that won't be a vehicle for political chicanery by either party.